David has pretty much stressed what we're going to do, and I'm looking forward certainly to the Q&A, or whatever we call it here. I would like to start with a question, though, that will kind of run through the theme here. And the question is what we're here for, is what makes a good judge? We all talk about we want good judges. Is it the law school they went to? In my experience over that many years, some judges who went to prestigious law schools didn't turn out to be such effective judges. Others who went to, I suppose, what we call lower tier law schools turned out to be excellent. So I'm not sure that's much of a criteria. Experience in the previous practice, it depends. It depends what court they end up on. It depends what their previous practice was. Knowledge of the law is certainly important, more important in some courts than others. Obviously, if you're in the appellate court, the Supreme Court, maybe somewhat more important than another court where you're handling narrower legal questions, because that's a specialized court. The family court would be an example. Not that you don't need to know the law in the family court, but the issues are quite a bit narrower. What about a judge who simply moves cases well? Whether we like it or not, one of the prime court system problems is delay, it's crowding, and so forth. And in certain calendars, in certain courtrooms, you want judges who can move cases along. High volume courts, the district court particularly, which gets probably higher volume in terms of case numbers. What other kinds of things should be factors? Race, age, sex, so forth. One thing we do in Rhode Island, which I think is a real plus, remember, judging is not practicing law. Lawyers are advocates. They take a position, they have to argue it. Judges are more like referees, essentially. They apply the rules and they ultimately have to make decisions, so forth. One thing we do in Rhode Island, which is not unique, but pretty unusual, after any of these people who we talk about are appointed, they go to the National Judicial College, which is a recognized, it's been around for many, many years, and essentially it's basic training for judges. Rhode Island has always, and certainly during the time I was there, we sent all of our judges to that school as soon as we could. Some need it more than others, but it's very effective in terms at least of learning how to be a judge, I guess is the best way to put it. The second thing that Dave and Phil had asked me to talk briefly about is how we got to where we are in terms of the role of the judiciary, the, for lack of a better term, the power of the judiciary, but also the power of the legislature in our situation. We have to go back to a guy named John Clark. Many of you come from the East Bay, the John Clark Retirement Center, same guy. John Clark was a Baptist minister. Baptists can be very contrary. My wife and I are two of the remaining 200 Baptists in the state, I think. In any event, she can be contrary. I can't. But in any event, John Clark is the guy who, for all practical purposes, established our, for many years, ruling document here in the state, the King Charles Charter. Without going into all the detail, basically the time that John Clark's operating, which is basically the 1660s, Rhode Island was not a popular state with their neighbors. Some things also never changed. Particularly Massachusetts, where we had serious religious arguments going on between the two, and so forth. So John Clark takes it on himself to go to London, basically, and try and get a document which assures more freedom of religious practice in Rhode Island and so forth. You have to remember, Clark is going there. The early 1660s, this is still the divine right of kings period in Great Britain. This is the king is king because God made him king, etc. That doesn't end until about the 1680s, etc., etc. So he's going to try and convince someone who has literally godlike power to give Rhode Island more authority, more political, give up some political power, which, as we know, no one likes to give up. Interesting thing about it also is he writes pretty much he writes that document himself. The king apparently sort of says, well, you know, write something up for me, and if I can sign it, I'll sign it. So he does, and basically he gets more than he's looking for. He gets beyond just assuring some kind of religious liberties, protections. He gets how Rhode Island should treat the Native American population, which in those days was pretty unusual, treat them better, etc. But he gets two really important things which are important to us today. The first thing he gets is the power for Rhode Island to elect its own officers, particularly royal, well, not would be royal, but governors. Up to that, all the other colonies, pretty much, other than Connecticut, which was also a somewhat different situation, they have royal governors appointed by the crown, essentially. The charter says in Rhode Island you can select your own. The other thing it says is that the legislature, and this is where we start to come to the real point, it says the legislature has the power to enact its own laws. They have to honor British law if there's a conflict, but overall they have the right to enact their own laws locally. So very early on, we get a pretty powerful legislature as compared to the people in the colony and the rest of the colonies. From the date of the charter, 1663, we operate under that, as many of you may know, until 1843. The King Charles Charter becomes the longest existing charter anywhere of its type in the world, let alone in the empire, so to speak. So that's the situation basically until other things start to happen. We've all studied the Declaration of Independence and so forth, and the Constitution, et cetera, and we were probably all subjected to John Locke. John Locke, as I'm sure most of you know, is a British philosopher. In those days you could get paid for being a philosopher. It was like owning a football team. You know, somebody who was wealthy took on a philosopher and you supported him and so forth, and housed him probably, and maybe gave him an allowance, etc. And he was there to think good thoughts, or think intellectual thoughts. So Locke was one of those people. He wrote on a lot of things. He wrote about medicine, he wrote about religion, he wrote about science, but for our interests, primarily he wrote about politics, about political power, how it's gotten, how it's held, so forth. And if you trace him, you go back even to Machiavelli. Machiavelli talks about something which we'll get to in a minute. Then you move up to Hobbes, who basically kind of refined Machiavelli. And when you get to Locke, basically he said two important things for us today. First thing he said, which today we just take as a given, but he said, you know, the people have the power. Political power lies with the people. For us, not a terribly surprising statement, but you know, when Locke is writing, it's reasonably important. The second thing he says is the best way to implement the people's power is through an elected assembly, a legislature, whatever you want to call it. When those guys gathered in Philadelphia, first in 1776, Rhode Island is there, by the way, for that meeting. We're there for the Declaration of Independence meeting, so to speak. They don't go there, by the way, being told to go and declare independence. They went there for less than that. Some of them don't stay, they leave, they go home, because they weren't instructed by their legislatures to sign the Declaration or even to write one. But when they get there, they're all pretty much Lockeans, if we can use that term. Mostly all of them, were by standards of the day pretty well educated. And they would have had what we would call today a, quote, liberal arts education and so forth. And they would have read all those people I just mentioned. They would have read Machiavelli, they would have read Hobbes, they would have read Locke. At the time they're doing this, Locke is their guy, so to speak. And also, it fits. When you read the Declaration, you look what Jefferson says, it's absolutely full of references to Locke's, particularly with his second treatise on government, which was basically dealt with the questions we're dealing with today. So he's the dominant guy, basically. So their philosophy becomes, as Locke said, Power belongs to the people, and that power should be exercised by an elected assembly, by a legislature. Now, Rhode Island actually even signs the Declaration, as we all know. They're there, so forth. What happens, therefore, is even more power placed in the legislature. When we get to the Declaration, Rhode Island, as you all know, is not there. There are reasons that they're not. Some of them just being plain cantankerous, but there were other. One of the ones I always love is one of the reasons they didn't go. Does anybody know what they were printing on their own? Money. All right, they printed money. Great economics. You need more money, you print it. You know, maybe we could all do that. But I've always wanted my picture on the $10 bill. But they don't go in any event. But that obviously doesn't stop them from drafting a constitution, et cetera, et cetera. And if you look at the Constitution, it's the same thing. What's Article 1 of the Constitution is what? It's the Congress, it's the legislature. They clearly felt, it squares right along with our friend Locke and so others, they thought that's where the power should remain. And they deliberately, when you read the Constitution, they kind of created a pretty weak presidency. Presidency doesn't have a lot of anything in the United States Constitution. Originally, the evolution of it since then, of course, is a much different story. But they don't do much for the president. You know, they give him a lot of kind of things, ceremonial duties then. You know, he can sign treaties, but the legislature has to approve it. He can appoint judges, but the Senate has to approve it. He can veto, but the Congress can override his veto. So they clearly leave the power in the legislature, and that's reflected in the states. Rhode Island already had that tendency anyway, and although they don't sign the Constitution right away, they're not there, as I said, they didn't show up, so forth. They're not part of about 40 to 50 people who actually draft the Constitution. In any event, they're not there. But it reinforces the strong legislative concentration, power, so forth. If we then move it down to Rhode Island has, and this is, I know, near and dear to Common Cause's heart now, Rhode Island has at least among the weaker governors in the country. It's a recent, excellent study of that where the author categorizes, and she has a number of categories. One of them is weaker, not weakest, but among the weaker governors. Therefore, if you don't have much power, and this is now where we can start to get down to actual appointment of judges and so forth, if you don't have much institutional power to do this, then what you try and collect is some kind of leverage, bargaining chips, whatever you want to call them. And historically in Rhode Island, judgeships have been bargaining chips, without question. If you look prior to the Act of 1994, Phil, right? Prior to 1994, court watchers or political watchers, and there are some here today who support my argument here. If you looked at judgeships being appointed to any of the courts, it didn't make any difference which ones. But there was generally a discernible pattern. It wasn't exact, but there would be a judgeship open and that one went to the governor. Another one would open up and that went to the House. Another one and that went to the Senate. And you know, it's if you take the time to look, let's put it this way, it becomes not crystal clear, but pretty clear. And if you worked in the system, and several people here have, I'm sure they probably wouldn't argue about that. It was a question of leverage between the two branches, and the governor didn't have much, but that's one thing the governor had. He could appoint the judge, the Senate had to approve. So it was that kind of relationship. Not to make a judgment whether that produced bad judges, good judges, whatever, but that's simply the way the system worked. The next, I guess, logical question is, what do other states do? Rhode Island, of course, always, well, you know, you're unique, you do things badly, and so forth. If you break down how other states do this, there's a ranking. There's an organization called the American Judicature Society. They're a professional organization who, as the adjudicature indicates, they look at these kinds of questions. And they every couple of years they update it, but there's a matrix, there's a chart they use that shows this. And basically it breaks down to 3 or 4 different methods. I'm not going to go into great detail, but I want to mention them enough so we understand what other options may be or could have been, so forth. About 10 of the states basically have absolutely straightforward partisan elections. You run as a Democrat, a Republican, a bull mooser, or whatever your choice is, so forth. 19 of them have what are called nonpartisan elections, but people who look at it say they're not really very nonpartisan. The parties tend to back a candidate one way or the other. They don't carry the label, but functionally there are candidates supporting them. The argument, of course, which is if we were sitting here and doing a course in logic, the argument for elections is that it gives the people a role in selecting judges. You know, it's hyper-democratic, small d. That's true. The problem with that, though, is essentially this. How responsive should judges be directly to the public on a case-by-case basis and so forth? Judges, a lot of judges, all judges, but some more than others, have to make difficult decisions, sometimes unpopular decisions. For example, the case you were talking about, which is also near and dear to Phil's heart, the speech and debate case that the Supreme Court decided. I'm sure you're all familiar with that. It was a question of how much was a person protected who was a member of the legislature who said or was certain things. The court ruled that speech and debate was protected. Other people didn't think so, so forth. That's a tough decision, difficult decision. If those people had to run for re-election after that, or shortly after that, you know, what would happen? And I'll tell you what will happen, maybe not in that case, but often happens in elected systems. First of all, beyond the fact that you need money to run for a judgeship, any kind of campaign, the question becomes who gives money to judge campaigns? And the answer is pretty obvious, at least a lot of attorneys. I'm not indicating there's any great corruption there, but that would be a source. Who else? How many of us here who are going to give money to a judge to run unless it happens to be your brother-in-law or your son or something else? So you have the money factor that comes into that. Second factor you have, and I'll give you one quick example, is that judicial elections, whatever the system, partisan, nonpartisan, or what we're going to talk about in a minute, get very little attention. They're a long way down on the ballot, and if for those of us who have all been voters for years, it is absolutely true. When you study voting behavior, the further you go down on the ballot, the lower the vote. People either lose interest, or they just don't know, so they don't vote. So judicial elections of whichever kind get proportionally very little attention. What that means is, if I'm a judge who's made an unpopular decision with a fairly organized group, I'm quite vulnerable. A friend of mine, who was a Denver juvenile court judge, good judge. That's an editorial comment, but he was. He fit, worked hard, et cetera, so forth. Issued an opinion where he said he would no longer commit juveniles to the Denver juvenile facility because the conditions were so terrible. Became a media item, obviously, as it probably should have, and so forth. 2 really small groups who were upset about that got together and defeated him in the next election. Now, we can make a judgment. Should he have been defeated on that issue? I don't know. But it's another one of the problems with elected systems. So we have partisan elections, we have nonpartisan elections, and then we have something which is generically called the Missouri Plan. Missouri plans are different, and there are variations on them far beyond what we have the time or probably the interest to go into. But Missouri plans basically are this. Generally, someone will appoint a judge, usually a governor, and that person takes office. And then after a certain amount of time, varies, but after a certain amount of time, that judge's name will go on the ballot, and the question, nobody will be running against him or her, but the question on the ballot will be, should Judge Jones be retained? And if obviously, if the vote is yes, Judge Jones keeps his or her job, and if it's not, then the seat is vacated, and the appointing authority appoints somebody else. It's supposed to be a better system, but it suffers from some of the same problems that we just talked about with kind of electoral politics in general. It's widely used, however. About 4 states use just straight gubernatorial appointment. In that case, it's not for all courts. It depends on which state it is, and some courts are direct and some have different process. But about 4 have direct gubernatorial appointment where there is no legislative role particularly. 2, interestingly enough, still have straight legislative selection. Governor has no role at all. The legislature basically selects all the judges in the state. And then the last category, of course, is merit selection, which is, since 1994, that's where we are. So Rhode Island, in a sense, ranks, or is listed among, or whatever, what is supposed to be, at least, the quote, best system. Maybe it's the best of a lot of other not-so-good ones, but the point is, we are, since 94, when they made significant changes, as I'm sure many of you are already aware, we are now in that category. That's about 15 of the 50 states use merit selection. Okay. Maybe before we, and I know Phil would like to get to Q&A and so forth, basically we should probably very quickly review what the process is with the nominating commission. It was fortuitous. Any of you read this morning's paper?
Yes.
I called them yesterday and said, would you please run that article? So I'm doing something here tomorrow. Basically, the process is this. And then we'll talk a little bit about maybe the makeup of the commission. I would rather save that until the Q&A. Basically, the process is this. The commission is supposed to advertise vacancies. I believe there are 4 they're dealing with this morning, 1 district, 1 in Superior, and then 2, and I think in workers' comp, I believe. But in any event, the 4. They have to advertise them. Anybody, well, not anybody, theoretically can apply, but we have to assume that a fairly large number of people, and there was, applied. Probably all attorneys. Interestingly enough, there is no requirement in the Constitution, particularly for the Supreme Court, that you be an attorney. Same with the U.S. Supreme Court, by the way. And in the earlier days, particularly of the Republic, we had people on the U.S. Supreme Court who were not attorneys. Unlikely to happen today. But in any event, they're supposed to advertise, and people can apply. And from the people who apply, the commission will decide who they're going to interview. Not yet put in the short list, but just interview. And they'll eventually, from that list, the law says they have to select 3 to 5 vacancies for each position. That makes a list which is then submitted to the governor by the commission. And the governor is supposed to select from that list, the law says, within 21 days. Something which may come up when we sit and talk about this. Assuming the governor chooses 1 from each list, or whatever, the nomination goes to the Senate. The Senate holds hearings, confirmation hearings, where anybody can go and testify for or against this particular candidate. They're obviously an open process. And the Senate will confirm, or not, but generally probably does. And then that person would take their seat, so to speak, literally. There are a number of questions that arise, and I'm sure we'll visit these when we take our seats over there. One is the makeup of the commission. Now understand, I spent obviously all those years in the court system. So I had an opportunity to watch this process. I didn't impact it in any way. But I also know how the court system, as a system, not individual justices, but how the court as an institution thought or thinks still about some of these things. One would be a question about the makeup of the commission, and this is not in any way to denigrate the people around the commission or anything else. Makeup of the commission, basically, when you boil it down, it's a rather lengthy, so many here nominated by this. When you really boil it down, it's a 9-member commission. 5 of those people are appointed by the General Assembly, basically. Or they are people submitted to the governor, and then the governor chooses from their submission. 4 of them are from the governor directly. That makes 9. So obviously, how many are from the judiciary? None. And the argument would be, and I think it's a valid argument, the judiciary has no role in choosing people for the legislature or for the executive branch. So one of the arguments is always, why should a commission made up of executive appointees and legislative appointees, why should they be choosing judges? You can like that or not, but that's one of the arguments. The other argument is, in a sense, if we're trying to choose, quote, good judges, qualified, and all of those things we talked about very briefly, who could be a better judge of that than maybe judges? Now, certainly, I'm not going to create a commission which has a majority of judges, but it's a 9-member commission. We could make it 11 members and appoint 2 judges, appointed by the Chief Justice or something. Which not only, it isn't so much voting leverage, but also it's just having that information, having that available, having that experience. I have no explanation as to why the commission in '94 was formed as it was. Phil may, I don't know, I don't. But that's one of the arguments. Second thing that could be a problem, and again we talked about this, although it just became less of a problem, for a number of years, the legislature at the end of each session would pass, usually they'd tack it on to something else, but they would pass a bill which said that governors could look back 5 years of previous lists. 5 years, and I can say this because I look around, I'm probably the age of everybody else here. 5 years at the time when most of our judges get appointed in terms of age. Not all, we've had some rather young ones for interesting reasons sometimes. But 5 years is a long time. Right? I don't know about any of you, but I don't think I'm quite the same person I was 5 years ago. And it's unclear, other than the fact that it gave the legislature, I guess, and governors a little more choice for whatever. It's unclear why they used to do that. Well, this year they did not do it. They have to do it at the end of each session. In fact, the Journal this morning notes that they didn't. I was unaware of it, and I think Phil was aware of it until we both read it this morning. So that is gone. At one time it was problematic. At least a lot of people thought it was problematic. The time frame, allegedly governors have 21 days. The law is very clear. Most governors up till now, recent governors, I don't think any of them have honored the 21-day provision, at least not routinely. It's not clear to me why. I know why they don't do it. It's not clear to me why it has not been some action taken. The law is very clear. It seems to me somebody withstanding the right to file a suit, probably a commission member, could file a legal complaint and say that any governor, I'm not picking out any governor, they've all done it, I think, in recent history. It seems to me they could say, the law says 21 days, and you're not doing that, so whatever. But in any event, we'll see. I'm not sure, are these the first gubernatorial appointments that our present governor has had, the first judge appointments? I think it is. So we'll see. But up till now, it's the 21 days that's sort of been ignored. Question, which is, I'm not going to take it up now because I think it'll come up, is this question of magistrates. Sort of junior judges, if you call them now. They wouldn't like that term, but basically. That's an interesting question, and I think I can shed some light on that historically and what happened there and why it happens and what the court's position would be on those, by the way. And I guess, lastly, so to speak, judgeships, whether we like it or not, are still bargaining chips. We've changed the politics. To some extent, we've made it a little more open system. But they are, and I think will always remain so. There's a point beyond which you cannot legislate human behavior, out of existence. The system is what it is. It's not really a system anyway. It's kind of an association of vaguely related events and organizations and so forth. We talk about the criminal justice system. That's being very complimentary for it. The system is more viable. It's more open, I think. And basically, though, the bottom line still becomes, what makes a good judge? We keep changing the system, but defining that is very difficult. So, I'm done.
So Bob, do you want to come over and let's sit down here and let me put a couple of questions to him first, if I may. Since we've started with a couple of things here. I should say first that this is a very interesting conversation for me because for years I knew Bob was there in the court system, but I didn't know him. And I was able to, so I was watching from the outside on a number of these questions, and Bob, of course, was, and I could talk about what I saw. Bob was on the inside. He couldn't talk publicly about what he saw. I want to pick up a couple things that you mentioned that really relate. The question of the Judicial Nominating Commission, its membership and its process. Those of you who have read that section of the book know the Bar Association and Common Cause both strongly urged the creation of a Judicial Nominating Commission following the American Judicature Society model, and we used some of their language and referenced what had happened in other states. We wanted 11, and we wanted a couple of independent lawyers on that commission. Judges could serve the same function. But the goal was to have some people on the commission who were not political stooges, if you will, who were not accountable to anybody except their constituency, and we certainly thought the Bar Association would provide a lot of that. If you've read that section of the book, you know that the House leadership said in no uncertain terms, that's a deal breaker. If you insist on that, we will not do it. It will not happen. You will not have any independent people on the Judicial Nominating Commission. So that's one of the issues. I want to just quickly, while Bob is here, Bob, get your take. You were there behind the scenes during the two major scandals that I relate in this book. One in the first chapter about Chief Justice Bevilacqua, the second one that broke in 1993 and became the source of motivation that led to the creation of, the pressure that pushed for major change. I wonder if you'd tell us about each of those scandals in terms of what you saw going on from the inside, because sometimes things look bigger on the front page of the paper than they are in reality, and I wonder if you'd speak to both of those.
Yeah, to some extent, and let me first of all, I think it's important to understand before I do that, what the history and the structure is, and I won't take a long time with this. In 1968, Frank Leach, who many of you may know, the Leach family, was a Superior Court judge. He left the bench to run for governor against John Chafee. The issue was in income taxes. So the point is, Frank Leach was the winner, so to speak. What he did then was, and he'd come from the courts, obviously. The courts at that time were not as, it would take me longer than we have to talk about the condition of the courts at that time. There was nothing. There was no centralized management in any sense at all. There was no centralized budgeting. Each court had its own. The facilities were terrible. In West Warwick, we were literally sitting in a converted chicken coop. Many of the district courts were in police stations. So you got arrested by the police one night and ended up the next morning in the district court in the same building, et cetera, et cetera. They had no information systems. They were operating with archaic three-way fold kinds of things. And so what the point is if anything ever needed organizational help, that did. The Act of 1969, the Judicial Reorganization Act, basically created not the first in the country, but one of the first in the country. It was generally referred to as a unified court system. It took all the courts and pulled them together. All the courts at the time, some others were added later, but that's a different issue, pulled them all together in any event. And what it did is it established the position of two important things. Established the position of state court administrator, and it gave the Chief Justice and the administrator the power to prepare and administer the budget. And I'm sure we all know if you have some control over money, you have tremendous impact in the organization. So that was probably the most important thing they did. At the time, when it all happened, Chief Justice was an individual named Thomas Roberts. Some of you might remember Tom Roberts, but he was my first Chief Justice, so to speak. Basically what happened is he did not want to appoint a separate individual to be the court administrator. So he appointed the then clerk of the Supreme Court, a guy named Walter Kane from Smithfield. Some of you might know Walter. In any event, Tom Roberts made Walter Kane not just the clerk of the Supreme Court, but also the court administrator. Okay? I was sent down there, as David indicated. I was then doing management studies in the Department of Administration. I was sent down there to organize this act, to get these things going, a personnel system, a budget system, all of those things. And very soon I inherited, I got the title of Deputy State Court Administrator. From that time on, basically, the clerk, Supreme Court Clerk's office, was a separate entity, and the administrative office was run basically by me as the deputy administrator. Have I confused everybody? Okay. So there was a line here between the two. The best way I could describe it is that court administrator's office does for courts, judges in courts, what hospital administrators do for hospitals and doctors. That would be the same. It's all the support systems. The court administrator's office has nothing to do with assigning judges to cases, assigning judges to courtrooms. That's done internally in the various courts. But we do all the underlying things. So that's the setting, so to speak. As far as, what did we see in the court administrator's office during both of these things Phil mentioned? Probably a lot less than you think. Days would go by that I would not see the clerk of the Supreme Court, so to speak. We probably very often, me and the people who work for me, which was most of the people in the system actually, within the Supreme Court, very often we found out what you all found out in the Providence Journal. I mean, it wasn't like we were involved in that. And if you look at what was involved in both of those situations, they had very little to do with the day-to-day operation of the court. So I guess the answer is, did it have a tremendous impact? It did. I mean, I had people who, for no reason at all, I had one individual, one guy, who could have had in no way any connection with everything that was going on, and he was getting up every morning at 3 o'clock so he could get the early edition of the Journal because he was somehow scared to death that he was going to be in there. And for no reason, absolutely no reason. So the effect on morale, is a good question, was huge. But in terms of the day-to-day play out of that, we had relatively little impact. We simply it wasn't our problem, This is not quite the same thing as, well, I was just following orders. But it simply didn't impact us in any direct sense because all of the things involved in that were not our problem, and we had really no knowledge of it. I mean, I don't want that to sound like I'm trying to say, well, but that actually is the fact. And that split still exists, by the way. When you read the article this morning, there's another article in the paper that Rhode Island's going to host the national convention or whatever. And you notice it says court administrator, Joe Baxter, who's now the administrator, he's arranging that and so forth. That, by the way, is a big deal, hosting that conference, but it's another issue. But there's also a clerk of the Supreme Court now, because what happened when, in 93, when Justice Weisberger and I ended up there, for all the reasons we know, we did a formal split of it. So there is now a court administrator who was me, and then another guy after me, and then about two after me actually, and now Joe Baxter, and there was a clerk of the Supreme Court. Now, and also I want to answer one question, because it almost always comes up when I do this. They say, well, does that mean we created 2 new positions, you know, and spent more of the taxpayers' dollars? No. What we did was, we abolished the deputy state court administrator's position, which had been me, and we didn't abolish, but we promoted the deputy clerk in the Supreme Court and didn't fill his position. So I can actually say, for one of the rare occasions, we actually saved significant money, and because we basically eliminated 2 people. And so now it's much clearer, but it's a quick summary, but hopefully that's useful.
In your summary of judicial selection, let me ask one more question and we'll put it out to the group. I'm watching the clock because Bob has to also be on the road very shortly.
I have to deliver my wife to a train because she's going to New York to do grandchildren duty. So.
You didn't refer to the fact that the Grand Committee was electing justices, and that Chief Justice Bevilacqua was the Speaker of the House,
right,
who essentially orchestrated his own election as Chief Justice.
Right.
Yes.
And 10 years later, when he fell in scandal, which we probably won't talk about now, Matty Smith was the Speaker of the House, and he orchestrated the election of Tom Fay, a family court judge, as Chief Justice, and then Fay turned around and appointed Matty Smith to become administrator of the court, and you had to deal with both of them. I wonder if you'd speak to us briefly about the politics of the General Assembly electing Chief Justices, and how that changes now as you've seen it change under merit selection of judges.
Well, I think the Grand Committee was a bad idea, but it goes back to what
All the way to the
we
road charter.
were talking about before. You know, it goes back. That was a legislative power. Nobody gives up power very easily, all right? And they were going to do that. I mean, how often did they get to elect a Chief Justice? Not generally all that often, because as we know, our judges are life tenured. There is no mandatory retirement age. They're there as long as they want to be, which is something else we should probably change, but it may be beyond the scope today. I think what we should do is have a retirement age, and then give the chief judges of the various courts the authority to call back some of these people if they need them, which they have now. When a justice retires, depending on whether they go out at full pension or three-quarter pension, the chief judge can ask them to come back and sit, and we do it commonly to replace people who are sick or whatever. Go back. The Grand Committee was a bad idea, but we have to understand why it lasted so long.
Sure.
You know, I mean, you're not going to give up something which, as I say, how often do you do it? But if you get a chance to do it.
We were one of only 3 states in the early 1990s that still had Grand Committee election of Supreme Court justices. And of course, in the bloodless revolution of 1935, once the Democrats took over the Senate and were already powerful in the House, they were able to vacate the whole court, sack the court, if you will.
But the interesting thing about, sorry.
And then go ahead and appoint a new court that had a new balance. Go ahead.
Oh, I was going to say, what happened was, and there also, it was, that's really what you just alluded to, they vacated the court. It was a 5-person court, as it is now. They vacated the court, but then they very carefully appointed 3 Democrats and 2 Republicans. Whereas they could have appointed 5 Democrats, but they didn't. And it's interesting because for years after that, that balance was always pretty much maintained.
I think it was constantly maintained.
I think it still is. I'd have to look at the personalities there, but I think it probably is still 3-2 people who are at least labeled as Republicans or Democrats, sometimes very vague labels also.
What was the reaction within the court? Last question I'm going to ask, then we'll put it out here. What was the reaction in the court in fall of 1993 when the word came that there were pledges made that legislators, the majority of the Senate and the majority of the House, would not go into the Grand Committee to replace Tom Fay?
I don't think anybody thought about it. I mean, I thought about it, but I don't think it was a major issue. I mean, it's interesting. And all of us who spend a career in government, and I was mostly in state government. I spent 3 years in New York working in a different kind of setting. But it's interesting. One thing you live with in Rhode Island is there is a very low regard for state employees. No question about that. I mean, you recognize that. And you sort of learn, you learn to live with it, etc. It's not an editorial. There are a lot of very good people there who come to work every day, do what they're supposed to do, and they care about it. But as far as the average state court employee even, be terribly concerned about a change in the Grand Committee? Probably not. It was above their pay grade, to use that tired phrase, I guess. But yeah, I put it this way: when they decided to change the Grand Committee, it was not conversation in the coffee room.
Mm-hmm. Let's take some questions we don't have a whole lot of time, but let's take questions.
I have one.
All right, go ahead, Dave.
Bob, you mentioned earlier about magistrates.
Yeah.
An issue that does come up. They're a different kind of judge. Should they be under the same selection process and criteria?
Probably, but it would be very, very difficult. First of all, let me talk very briefly about magistrates. Magistrates, I'm sure most of you know, are it's pejorative to say they're junior judges. They are judicial officers with limited jurisdiction. Depends where they are and what they can do, and so they are not full judges in that sense. A lot of them, however, make very reasonable, very important decisions. But for all of that, they are not, as is indicated, they are not subject to the Judicial Nominating Commission. They're appointed by judges in the various courts, chief judges in the various courts. Family Court has the most of them. Superior has, I've lost all the numbers totally now, but 2 or 3. There are probably, my guess would be, a dozen to 15 of them, could be more.
Actually, there are 21 or 22.
There are that many now.
And there's a list in the afterword of the book as to who they are and what positions they held before they got to be magistrates. Mm-hmm. And most of them were counsel to the Speaker of the House or counsel to the Senate President. Stephanie's nodding her head. I shouldn't name people, but Stephanie, do you have a word about that in terms of what you saw happening?
Or wife of John Harwood. Yeah. She got a nice fat magistrate.
So you have an appointed judge appointing someone who will then serve in a very close to judicial role, and inevitably will stand up later and say, I did such a terrific job as a magistrate, I'm ready now to be a judge. And that's what I've heard many times.
There's no question to step on the ladder. I think, to me back to what I said, I think they should go through the nomination commission process. However, it will be extraordinarily difficult to make that happen.
Of course.
I wouldn't take that on as one of your causes this year. And I'm not being sarcastic. If I could just finish, can I just finish quickly? The idea, the concept of magistrates, however, in the system is not at all new. They're called magistrates now. But prior to the court reorganization that I mentioned in 1969, the district courts, and there were 13 of them in a small state like Rhode Island, they were the ones sitting in the chicken coop or various police stations and so forth. There were 13 of them. They each had a clerk. Many of those clerks, not all, the bigger areas not, but many of those clerks were part-time. They were the clerk of the court, but they also practiced law, which right away starts with a conflict.
Yes.
Yeah.
Yes.
The next problem you would have is that Tuesday and Thursdays, the clerk in the whatever division would be sitting essentially as a magistrate. We didn't call them that then, but that's really what they were. They were this same kind of officer. Tuesdays, Thursdays, I'm the clerk in X division. I'm sitting as a magistrate and attorneys appearing before me. Right? Monday, Wednesdays, I'm practicing law and I'm appearing before a guy who appeared before me because he's the whatever. And now, I have to say, there was never any, to my knowledge, and I went back, by the way, a while ago, several years after I retired. I went back 50 years, basically, looking at, I made the assumption that if there was some judicial scandal, quote unquote, that it would be on the front page of the journal. And so, tediously going through microforms and microfilm of various types and so forth, looking for that. I never found anything like that. In fact, I found only 4 that were active sort of things you'd call. 2 of them were obviously Double Aqua, Smith and Fay. We had a judge who was clearly taking bribes, who was arrested convicted, did time, and so forth. And we had another one which was really more of an ethical violation than it was the law. But you'll have a very hard time changing the magistrates. But the courts will guard those, not just because who they might appoint or not, which is a problem, but it's another prerogative that the courts have, and they sort of have this persecution complex. They don't have very many.
Let's take Ed and
that's
then
fine.
back.
Well, at the very beginning, you said, what qualities should we look for in a judge?
Right.
And the first thing that came into my mind is something that nobody can measure, moral and ethical integrity. And it's the same in every profession, probably every industry. You can hire a person with the best qualifications, but that is unmeasurable until he proves
Exactly.
to be that.
And that's the problem. And I don't know how you measure that. I mean, sure, they do an investigation. The nominating commission investigates pretty thoroughly. I mean, the applicants, and there were certain things that they have on the proscribed list. You can't have done this, can't have done this, whatever. But once that's done, how do you predict human behavior?
I dealt with Thomas Fay up in the legislature. I was very active at that time. And as far as I was concerned, he was a nice, honest guy. I couldn't tell you.
And he was, by most standards, the family court, by all standards, a good judge.
Yeah.
He had a good reputation. He did all those things that we expect to be done.
How do you then explain him and Matty Smith doing this building and awarding arbitrations to people who were tenants in their building? I mean, I think that's a real problem.
Yeah. Bad judgment. I'm not trying to get off it, whatever. But it was. I mean, it's no question any Chief Justice, they still have today, have the power to appoint those kinds of people. But somebody should have said, I guess nobody did. I don't know.
Dave?
Everybody's going to get sick of me asking this question, but is there a model around that we can, if we had the political will and the guts to do it, could emulate? You mentioned the Missouri plan that had something to do with the nominations, but is there any place that does it measurably better?
Ours is the Missouri plan.
Well, we don't do retention elections. So.
No, but aside from that, but the process that Missouri conceived in 1936 or 39,
Right.
that the American Judicial Society then embraced, and that's an association of judges and lawyers, was what we tried to adapt to the Rhode Island example. And again, there's no perfect system, but I think we could argue, one of my arguments with Arlene Violet, who was here last week, was she was saying we need to elect judges, and many of us said that's the worst way.
Yes, without question. I don't want to sit here and say we're about as good as we're going to get. There were clearly some things we could tune up here, but fundamentally, as I say, we're in the best group right now, and whatever. And there's some things we tune up. As I say, I'm concerned about the 21-day. The reason I care about the 21 days is not magic 21 days, but 21 days gives you longer for the political process to create problems. If a governor at least has to make a choice within 21 days, not that there won't be politics involved, there will be, but at least it's not holding on to that chit for 3 years. So I can play it later when I can really get something good.
Jeff?
Just another comment on an election of judges, which I don't think was mentioned, is that judges who have to go up for election, they're always looking over their shoulder and making political decisions on the bench rather than legal decisions.
Yeah.
And I just can't imagine anything more dangerous than that. I did want to ask a question about the article that was front page in the paper this week. It showed all the various judges who have been appointed and got into the racial issues. Do you see a real problem with the fact that our judiciary is almost exclusively white, and there are people of color
Let me
get a
respond to
bad
that,
shape
Jeff.
because of that?
It's the system, again, institutionally, has been well aware of that, and it's a problem. Now, there are two different theories on that, however. One theory is that minority defendants appearing before a minority judge, it was in the article, the theory would be they'd feel more comfortable. There's another whole theory, there have been some studies done, which I can't cite to you, but I've read them, that say that a lot of minority defendants, if it's a criminal case, but whatever, appearing before a minority judge, it's like minority policemen. They take the feeling this is a person who's sold out. He's joined the establishment, et cetera, et cetera. And I'm sure it varies individual. But the problem with recruiting minorities, there's a couple of problems. First of all, the number of, this was in the article, the number of minority attorneys in the state is really very small. Okay? I don't know what the numbers are, but current, but it was always, you could almost name them on one hand. We had 2 or 3 or 4 at the time minority judges. So the numbers are very small. The second problem is that although they are growing, more in the Hispanic population than the African American population, but because they're growing, the pool is a little bigger, but many of them are sort of at the beginning of their career. So they're not yet either interested, generally, or ready to be a judge. And the third problem is, if you're a qualified minority attorney, there's an awful lot of competition for your services. The big firms, they want them, and quite candidly, they pay a lot more than being a judge pays. Not that judges are not paid, pretty well they are. But basically, the big firms, particularly, the E&A, was not longer E&A, but whatever it is now, the large firms and so forth, are looking for these people. So given a choice, they'd probably come out of law school with big debt, et cetera, et cetera, et cetera. We, the state courts, are generally not really in the mix. If you look at the ones we have had, they were later in their careers. Roger B. Thompson, Walter Stone, Ed Clifton's. Yeah, they were people who were, in a sense, ready to become a judge in terms of their career path.
But in terms of in terms of the actual justice of it, the process and the justice of administering justice, is it a problem?
I think it's a problem. We were very careful, and again, it's in the book, to push for language that the Judicial Nominating Commission should be representative of the diversity of the state. And the hope was that that would also be present in the courts. And sadly, it's not. And I would differ from Bob on that as one whose background has been in minority communities a lot of the time, and since the tragedy of people feeling that the courts and the whole system is white, doesn't represent my values, my experience. They don't have a clue what I've been through, and that's a very tough one. And some of you saw the story on 60 Minutes about the man who was railroaded and spent his life, most of his life, in prison on death row, no less. Was finally cleared and died a few weeks later. And it's very powerful last week on 60 Minutes.
I should say this, we pushed, Justice Weisberger and I pushed to the extent that we could on this very issue. Justice Weisberger, may he rest in peace, many of you knew the justice, and you couldn't get a guy with more integrity and more internationally known and so forth. We were aware of that problem, and we pushed naming an individual. There was an individual at a lower level in the system, in fact, a magistrate, who was African American, well-qualified person, and we both pushed the then governor, who was obviously an elected governor, and got nowhere with it, and I can't explain why. But it's not that we are unaware of it, and we tried, in the ranks of people we hired, well, there's no question when he and I were done, the workforce and the courts, because that's where it's really important. It's one thing that, this is nice that the judge there happens to be, but where it's really important is when you come into the clerk's office. Remember, the courts deal with troubled people. They don't want to be there, understandably, who does? And when you walk into the clerk's office, where you're trying to do some legal business because you have to, and you look behind that counter, and there's nothing but white faces.
Yeah.
All right? That's, in a sense, more immediately intimidating to someone than when they get into the courtroom. And we tried, and we were successful. Our numbers, the state keeps numbers, so percentage of minority employees. Ours went up markedly during, and then, to say I'm proud of something, but that was one of the things we tried to do. So it's doable, but it's doable, you see, in things like clerical employees, whatever. It's much more difficult when you get up to the judicial level, for all sorts of reasons. We could hire the people we wanted to hire, and if we wanted to give preference to someone who was a minority, we could do that. We had no no influence on who ended up wearing that robe. So.
Bob, thank you. This has been a really useful event, and thanks a lot.